Good morning, everybody, and nice to see you all. The purpose of today's session is to talk about investigations. It's an area that we have seen an increase in interest in. It may be that there is both an increased demand to investigate, but also absolutely an increased scrutiny on investigations. So, Tamar, if you could just flick onto the agenda for us. So I'm Alice Reeve. I'm an employment partner in the team at VWV. I'm joined today by Tabitha Cave, who is going to focus on the pupil parent investigations and is a partner who leads on our regulatory work. And also Simon Martin, who is a consultant with Narrowkey HR, who's going to talk about the practical things. Now it sounds like we've got some sound issues. Tamar, is that?
I would just like to ask everyone to check their audio settings. So if you could go onto the microphone, I think we're getting there.
Great. Just give everybody a moment. Hopefully everybody can is great. It looks like everybody is sorting that out. Fantastic. Thank you, everybody. So in terms of what we're going to cover today, I'm going to kick off with talking about some of the preliminary considerations, things you need to get right before you launch the investigation. We're then going to move to some of the more practical advice and look at the guidance around carrying out an employment investigation, largely led by Simon. We're then going to have a short break, just so people can get away from their screens for a moment, and then hand over to Tabitha, who will look at some of the particular issues relating to pupil parent investigations. There will be time for questions. We're hoping to slot in some questions as we go, but if not, we've got some time at the end as well. And please do put your questions in the Q&A box. So moving on to look at some of the preliminary concerns that you should be thinking about before you launch the investigation. And I think all of us on this call would say that there's often an imperative to hurry things along, to move forward quickly, but setting off on the right track and sorting out some of the initial issues is really, really important. And often when we're contacted, it's because things have gone off without due consideration being given to that. So Tamar, if we can flick on to the next slide. There's a lot of tech issues going on. You're happy to move the slide? I'm going to carry on, then hopefully you'll catch up with us. First of all, we wanted to reflect on what the purpose of an investigation was. What are you trying to achieve? Well, it's not magic. Essentially, really, it's establishing the facts of a situation. So that's a quote from the ACAS guidance, which I think is a really useful one, that the whole purpose of the investigation is to establish the facts, a fact-finding exercise to collect all the relevant information on a matter. And ultimately, once you've gathered the facts, that enables you to make an informed decision and make sensible decisions about the next steps with confidence to do that. And that's really what you're trying to achieve in all investigations. And there are some common themes that run through all of them. Many of you will have come across investigations in a whole range of scenarios. So as you know, I'm an employment lawyer, so I come across investigations primarily when an employee is concerned about something relating to their employment, and so a grievance investigation is needed. We're increasingly seeing whistleblowing investigations where somebody's concerned about malpractice across an organisation. You as an organisation may want to be investigating whether someone's conduct or performance has fallen short, and that needs an investigation. Parental complaints or pupil complaints will lead to investigations as well as other potential regulatory failings such as data breaches, health and safety concerns, or sometimes wider assurances as well. So, what's an organisation's approach to equality and diversity issues, for example, is the sort of thing we are seeing. And many of the themes that we're going to talk about throughout the day are relevant to all of those sorts of investigations. But it is helpful at the beginning and just moving on to think about what policies you've got that may apply. We can move on to the next slide. to think about what policies apply, and if you do have relevant policies, make sure you dig them out at the beginning. You will all know that failing to follow your own policy is one of the real concerns around fairness, and individuals will want to understand what policy is being applied as well. So think about what are the appropriate policies here. Sometimes they will dovetail, and that's one of the quite difficult things. Tabitha and I work closely together where a parent raises a complaint that is potentially about a member of staff, and then you may have both the parental complaints policy and potentially a disciplinary policy, for example, to consider, and you'll need to think about how the two things align and what are the roles and responsibilities within those policies and what are the relevant time limits. Sometimes there may not be an obvious policy, or you may not know which policy you need to follow. In those circumstances, please don't worry. It can still be really helpful to investigate and gather the facts, and then use that to determine what, if any, relevant policy is engaged or not, what steps need to be taken as a result. And in that instance, you can tell people that that's what you're doing. A classic example is when perhaps something goes wrong in the workplace and you're not sure whether that might be a capability issue with the employee. It might be that there's some issue with the school systems, or it could be misconduct. So you might investigate potentially as which could then potentially engage one of those other policies as well. So first of all, identify the appropriate policy, work out what the constraints are within that policy, make sure you map out the relevant time limits. Often time limits in policies are pretty tight. Sometimes that's absolutely fine, and investigations can be quite narrow. You can get on with it and can comply with the relevant time limits. Sometimes you will instantly realise that it is going to be difficult to comply with the relevant time limits in your policy because a more extensive investigation is needed. Or, as with many of these things, they arrive on the last day of term and you're not going to be able to comply. It is far better to have acknowledged that at the beginning and manage expectations. And if you need to extend the time limits, that you tell somebody that before they're passed, and certainly at the beginning. So you've got your policy, you've mapped out the desired time frame. You then need to establish who should act as investigating officer, and it's critical that it isn't just the person who is made aware of an issue. And we do see that mistake still happening, that perhaps a chair of governors is written to and they think they need to investigate. That becomes problematic because certainly in an employment context, you need to have separation of roles. So you would have an investigating officer who establishes the facts, then potentially that would go to a formal hearing, and ideally with somebody more senior who hasn't been involved, and then potentially an appeal, so somebody who's more senior than that, or a panel. So often in a school context, you would have an investigating officer at perhaps deputy level, Bursa business managers level. You would then have perhaps the head hearing the disciplinary, and then a panel of governors to hear an appeal. So that's how it often works. If you started too high and your investigating officer is a senior person in the organisation, be that the head, be that a governor, it can be very difficult to then have enough space and capacity within the organisation to have those tiered roles appropriately. So always stop and reflect who should be that investigating officer. Often it's internal. It needs to be somebody who isn't directly involved in the incidents. We often get lots of discussions about conflict. Conflict in an employment scenario here is that they weren't involved in the incidents that are being investigated. But actually conflict or perceived conflict could arise if perhaps they're their line manager or they've had issues in advance, so previously. So think whether there's somebody neutral who can investigate as well. Make sure that they've got capacity to do it, time and to do it properly, and think about their expertise, whether they've had sufficient training and knowledge to carry out that investigation. There will be times where you will think about whether to use an external investigating officer, and that's becoming more common. And obviously Simon will share some of his experience for doing that for many, many clients. The advantage of an external investigating officer is that although they perhaps don't know the school so well and the ins and outs, they bring a neutrality, they're external to the organisation, they can demonstrate impartiality to the issues, they're obviously skilled and experienced and can move things forward. forward, hopefully quickly as well. And it does bring a credibility. So where you've got those very difficult issues where there may be a suggestion that the school is marking its own homework or trying to brush things under the carpet, there can be real advantages in an external investigating officer. But you need to spend a little bit of time thinking about who the appropriate person is at the outset. Once you've decided who that investigating officer is, it's important to set the terms of reference. This is something that Tabitha and I are both quite geeky about and think's really important. But where you've got an internal investigating officer, that's really about putting something in writing. Can be just an email to appoint them as investigating officer, to explain if there is an appropriate policy, if there are appropriate time limits, and asking them what you expect them to do. It's fundamentally the same if it's an external investigator, but obviously it's more important to formally document things like confidentiality as well. Critically, you'll need to think about the scope. What is it we're asking them to do? You want to make sure that they come back to you and check in if something is outside of the scope. So if they're investigating a grievance, what if there's a counter grievance raised? Well, the scope should limit it to the original grievance, and then you can consider if that should be extended to the counter grievance. So manage the scope. And that's so that you can keep an eye on timeframes and manage something effectively as well. Also think about what it is they're being asked to do. In all cases, you would not expect a investigating officer to be, deciding a sanction, and that would make it unfair. But they could just simply be gathering up the relevant facts, the relevant documentation to support a process, but they may be going beyond that. You may ask that they make some recommendations. That may be a recommendation about whether something's to go to a formal hearing, or it may be a recommendation about how things may be resolved in the future, or steps that the school could put into place. But you need to decide whether that's something you want your investigating officer to do or not, and set that out in the terms of reference. And it should also think about whether the investigating officer can directly seek legal advice and who that report is going to be shared with. So you've given some thought in advance. Hopefully you're then setting off on the right track. There are a few, there's a few questions I'll pick up in a moment. There are a few other things that I just wanted to flag in terms of the very early stages of an investigation. If something, develops in the workplace before you launch in, you may need to think about whether there's any evidence that needs to be immediately preserved. Sometimes that might be physical evidence. So if something's happened, someone's tripped over a paving slab, can someone go and have a look at that, take photos? If there's an injury, take photos of that. Is there any IT that needs to be preserved? CCTV is a classic one where it gets written over generally every month. So make sure that if there is relevant CCTV, you've pulled it off, relevant to be looked into. And it may be appropriate to ask people who are involved to note up their immediate recollections of an event as well, particularly if something's going to take a little while before they're formally interviewed. You'll be aware as well that in a school context, there are many cases where it's necessary to think about involving external agencies. So where you have got an allegation of harm, you absolutely need to speak to the LADO first before starting your investigation. Again, I think most schools now really familiar with that. Back in the old days, people used to investigate first, and it's absolutely clear that that isn't what you need to do. So you need to contact the LADO. And then they will tell you usually that you're free to investigate yourself, or whether they want to move forward through a multi-agency meeting. Children's social care, the same approach. If you do notify the police, or if the police are involved, again, you will need to make sure that they have authorised you to carry out your own investigation before you begin, in order that you don't pervert the course of justice or impact or undermine their own investigation first. So those cases can be quite difficult, but the critical message for today is simply recognising if one of those obligations is involved, and then waiting to get authority before you then begin your own investigation. And finally, I just wanted to mention suspension in serious cases, or cases where you're worried about to protect both individuals, either where there's an allegation of harm, or potentially where it's going to be difficult to carry out an investigation fairly. An IT manager where it's an allegation of doing something inappropriate with the IT system, you may need to move them out while you carry out a fair investigation. Where you've got allegations of perhaps bullying by a team against a line manager, again, it may be difficult to carry out a fair investigation in those circumstances. So you would need to think about suspension. It should always be a last resort. If you are going to suspend, it's essential that the investigation happens as quickly as possible. You need to appoint somebody to support your member of staff during that period, and keep suspension under review. Just because you decide to suspend at the beginning doesn't mean that that needs to be maintained. If once you've begun your investigation, you realise that things are not as serious as they perhaps initially appeared, or you've gathered the information that you need. Equally, if you don't suspend at the beginning, but as it evolves, it becomes necessary, you can do that as well. I think that is the all the preliminary issues that we wanted to mention today before we talk about the employment framework. But I am going to, there were just a couple of interesting questions, I think, that I can pick up now. I say that. Sorry, I somehow can't see the Q&A. It must be in. Oh, hold on. I'm going to move on, and I'll look at that. I'll look at it when I have a bit more time. I'm sorry about that. I wanted us to move on then to look at the employment investigations, and I'm going to hand over to Simon, who's going to talk about this in much more detail. But I thought I'd just talk a little bit about the legal framework which we have, and then Simon's going to talk about how to effectively investigate in practice. So in terms of the employment law framework, it's in employment, there's quite a lot of employment law in relation to investigations, and actually lots of the guidance that's come out of employment case law and further guidance is relevant to wider investigations as well. So Tamar, if we can just flick on to the next slide. I've included here I mentioned someone's just asked about raising questions. Tamar, can I bother you about that? Sorry. Are they in the chat? Is it in the chat, the questions?
Yes, so
Okay, sorry, I was confused by that not having a Q&A. Let me
there is no Q&A, it's just the chat.
sorry, that's my fault. So they're in the chat box, please, if you raise a question. And in fact, there's one question for me here about, should the investigating officer make a finding? And the answer is absolutely not. The investigating officer should not make a finding. Well, in most cases, the investigating officer shouldn't make a finding. The investigating officer's job is to establish the facts and make a recommendation. It then usually goes to somebody else who will then make a finding on that. That is largely in an employment context. That's not always necessary. Perhaps, well, it's not necessary in a grievance where somebody could investigate and make a finding. It's not always necessary in a pupil parent process, which Tabitha will talk about. So it depends on what process you're following. It can be useful in many cases to have a separation of roles. So do think about that at the beginning, and think about whether the investigating officer is also the decision maker, or if it's separated. And if, as in lots of cases these days, and certainly it's imperative in an employment disciplinary context for that to be separate, the investigating officer needs to stop short before they make a decision. And then we've got a couple of questions about the sequence, about in terms of how you speak to different individuals. So Simon, you can pick up on that in your section, as you will, and also what's required in a capability investigation. We can come back to that if we've not covered it in Simon's section. So just to come back to the framework that we've got in employment law, I've started off, I wanted to mention a very old case. Most employment law happens, you know, it's very current, but this case is still good law, and it dates back to the 1970s involving BHS. And this looked at what was fair in terms of a disciplinary process. And it's still the linchpin, really, that in order to decide to bring someone's employment to an end, the employer had got to believe that the employee was guilty of misconduct. But they couldn't just simply believe it. They couldn't say, well, that's my view, it's an honestly held view, and I believe it. They've got to have reasonable grounds for that belief. And the only way that they can have those reasonable grounds is if you've carried out as much investigation as was reasonable in order to inform that view. And so when a tribunal is looking at whether an investigation was reasonable or not, they will come back to this Birchall test. And it's the reasonable word, which people get frustrated with the lawyers about, is an important one. that it's the investigation that needs to be reasonable. It's not doing absolutely everything. It's not leaving no stone unturned, but you need to make sure it's reasonable for the context. And generally, the more serious the outcome, the more thorough the investigation needs to be. We've also got some really good employment guidance, which we'll share with you after the event as well, but I'd recommend that if you're carrying out investigations, you read the ACAS Code of Practice on disciplinaries and grievances, which contains information about the investigation stage. There's a fuller ACAS guide, which expands on some difficult points, and there's also a useful ACAS guide on conducting workplace investigations and some useful materials that they have, and they're really good if you are carrying out investigations as well. And yes, we will share the slides with everybody and the recording after this as well. Simon, that brings my slot to an end, so I'm going to hand over to you to look at how we carry out employment workplace investigations in practice.
Hello everyone. I'm Simon. Was an employment lawyer for 20 odd years, and for the past 4 or 5 years, I've been HR consultant. So I do lots of investigations. And also mediations. But so I've looked at investigations from an employment law perspective, representing clients in tribunals, and also now doing them. So let's move on to the next slide. So what we're going to look at is the process you need to follow, the skills you'll need, and we'll also look at tackling some quite common issues that we see crop up in investigations. Right, next slide, please. So Alice has already touched on some of this. So in terms of what you need for in an investigation officer is skills. So I think skills is I think probably the most important skill is sort of being patient and analytical, not sort of jumping in with any conclusions, and having a curiosity about yourself, about just wanting to understand what's gone on. So I'll come on to talk about this, but the most helpful phrase an investigator can use is help me understand. So that's your approach. You shouldn't be out to prove a particular case. You should be happy to be led by the evidence. Even if you've got someone quite senior telling you the outcome they want, as a good investigation officer, you should be just being led by the evidence. Impartial. So there's some obvious examples. Like, for example, if someone's raised a grievance, you won't have the person who's the grievance has been raised against, who the grievance has been raised against, investigating it. But also, you will have, for example, if you've had a situation where I had active for an employer in a tribunal a few years ago, where the HR officer did the investigation, but the HR officer had an ongoing feud with the person she was investigating. And so she did a very partial and very biased investigation to effectively find evidence against him and ignore all the evidence that would have helped him. The other one, again, Alice has touched on, is time. So there's two things for that. One is, do you have time so it will be a priority? An employment tribunal wants to see that it's a priority for you. So it's not going to go to the bottom of your to-do list, but also in terms of the interviews themselves. So when you are interviewing someone, let's say you're interviewing someone in a serious case, let's say of sexual harassment, someone might find it very difficult to talk about that and might take quite a long time to where they're going to, until they're going to feel comfortable talking to you. So you might spend an hour, let's say, just sort of talking around the subject until they're prepared to start talking to you. What you don't want to be doing is looking at your watch thinking, well, I've got an SLT meeting in 10 minutes and I need to hurry this up. So you need to make sure that when you're doing the interviews, you've given yourself the time to do those interviews, and those interviews will take as long as they need to take. Right, so next slide, please. So the terms of reference, Alice has mentioned the terms of reference. As the investigation officer, the terms of reference, they're the questions that you need to answer. So it's really important that you, as the investigation officer, completely understand what you're being asked to investigate. And if you're not clear, and if the terms of reference are not clear, I would suggest you go back and say, exactly what do you want me to investigate, let's say you're investigating a grievance. The grievance might cover 5 or 6 subjects. It might be, for example, that 2 or 3 of those have already been dealt with previously because there's an ongoing issue. And so the organization may not want you to go back over that and say, look, these are the specific issues we need you to look into. And so it's really important that you are clear about that, because when I'm doing my investigations, I return to the terms of reference all the time. So when I'm preparing the interview questions, I'm looking at the terms of reference, and I'm always asking myself, in what way is what I'm about to ask this person relevant to the terms of reference? And the terms of reference, the questions in the terms of reference are going to be, page 1 of your report. So it runs throughout the terms of reference, and also the terms of reference are going to inform who you need to interview. And there was a question earlier about the sequence. So like, if you're doing a grievance investigation, you will usually interview the person raising the grievance first, so you understand what the grievance is, and quite often they might sort of beef up and add some more detail to that, or you might be asking for examples, because quite often a grievance might say words to the effect of, I'm always being harassed by this person, or I'm always being bullied by this person. And so you'll need to say, well, give me examples of that, because if you go and interview the person who has been accused of harassment, if you just say, are you always harassing them, they will go, what do you mean? So you'll need to get the specific examples of, on Tuesday the 5th, there was that meeting. And so you can talk about specific instances rather than just these generalities. So with a grievance, you tend to interview the subject of the person raising the grievance first, and then the subject last. With a disciplinary, you will usually interview the person being disciplined last. Right, let's move on to the next slide, please. So preparation. So before you do your interview, you'll think about the questions, and again, you return to the terms of reference, you'll read through any documents you've been sent, and you'll prepare the questions. But you mustn't be too rigid about your questions, because the questions can only ever be half of what you'll end up asking, because most of the questions will flow from the answers that you're being given. So you need to, it's more like subject headings. You need to discuss these particular areas. So you will give yourself a few questions as a starter, so you know the structure and you know the areas you need to cover, but it's impossible to write out all the questions. So let's move on. So the next one is note taker. Note taker. My preference is always to get a note taker present, because it's a lot easier with when you're doing the interview. You want to be listening to the answers and thinking about other questions you've got flowing from those answers. You don't want to be, I'm not the world's best note taker, so you don't want to be just frantically typing, trying to make sure you've caught everything, because you're not then thinking about the other points. Increasingly, we are seeing sort of AI, or as sort of like a transcript, but you've got to make sure that it's a good one. But I would always make sure that you're not just solely in charge of taking the notes. And confidentiality, that's really important. And what you'll do is you'll need to tell the people you're about to investigate the importance of keeping everything confidential. And you will also remind them at the start of the session, but it's important that before they go in, they know that this is a confidential exercise. So next slide, please. So you get into the meeting, the first thing you do is you need to give them a reminder about the confidentiality, that you don't want to share, you don't want them sharing this with and discussing their evidence with other people. And the next point is how their evidence is going to be used, because people need to understand that the evidence that you're going to give them, you may well be sharing with other people. Like, for instance, in a grievance, you're going to have to tell the people who are the subject of the grievance what's being said about them and give them a chance to respond. So it's important that they are aware that that the information you're telling them, although you've talked about confidentiality, you're going to have to share. Now, you won't be sending them all of the interview notes. the only people who should really see the interview notes should be the person who's instructed you, who's asking you to do the investigation. But you may well be passing on quite a lot of the evidence to various people to either check that evidence or to get people to respond to that evidence. So it's important that no one is under any misapprehension about what's going to happen to that evidence. Next slide, please. So questioning techniques in the meeting. As I mentioned, the most helpful phrase as an investigator you can use is "help me understand." What I think you ought to be very careful of is as an investigator, you don't want to find yourself in a situation where you're going to be saying, well, it's just one word against another, so I can't decide. Because if you're investigating, let's say, a case of bullying or sexual harassment, these episodes don't tend to happen in front of an audience. So it's always going to be one word against another. And so your job is to use the evidence you've got to try to arrive at a conclusion on balance, whose evidence you prefer. So you'll look at the detail they give. Quite often, if someone is giving you a lot of detail about a particular episode, you know, what the person was wearing, what their breath smelled like, where they were standing, etc., that's quite important. Also think about the cognitive load. And what I mean by that is if you've got someone who's doing lots of talking and lots of hand gestures, and then you ask them a difficult question, if they stop and have to think about it and pause for a long time, that's a change. And it's important that you note those changes, that they seem to struggle on particular questions. So it's important that you are thinking about that. And triangulation, what that means is you're checking their evidence against other evidence they've given, either evidence in the interview itself or evidence that you are. Sorry, I'm seeing a lot of questions coming in. I will answer those questions at the end, but I will get through this because I think sometimes what I'm saying now is sometimes the next slides might answer those questions, but I will get to the end and I'll answer those questions. So triangulation. So this is people's own evidence. So you're looking at what they've said in the interview. You'll also be checking it with, let's say, emails they've sent or meeting notes that you've sent. You'll also be checking it with other people's evidence. So if someone says, well, I was completely devastated following that episode and I came out and I was really shaken, you will want to interview someone who's met them just afterwards and just say, well, you know, how were they when they came out? And the other thing which is useful to think about is, particularly in cases of, let's say, sexual harassment, some people might have forgotten they've sent messages. Some people might come on post on social media or send a WhatsApp to a friend. So it's worth asking them, you know, have you or did you send any messages? Did you do any social media posts just after that episode? And sometimes they've forgotten, and sometimes triggering that will mean that they might dig that out, and that can be quite helpful evidence because that's really contemporaneous stuff. So it's important that you triangulate that what they're telling you with other evidence. Right, so next slide, please. Right, so I'm going to get you all to do a bit of work now. So here's the first poll. So if you want to just vote on which is, let me just move this so I can see the actual question. So you get given a list of 16 people by one person. What do you do about that? Right. Splendid. So that, yes, so 92% said, ask them what evidence they're likely to give. And this has happened to me. In fact, this has happened to me quite recently. In fact, the most recent one, the person gave me a list of 21 witnesses who he said I needed to interview. So that's exactly what you do. You say, well, what you tend to do is you will share the terms of reference with them and say, look, these are the questions I've got to answer. These are the points I'm looking into. What evidence are those 16 people going to give? So talk me through, explain to me what evidence they're going to give. And it might be, for example, that there was like a particularly difficult meeting where the manager talked over someone or undermined them, and there were 5 people in the meeting, and they said, all 5 people witnessed this. So you don't necessarily have to interview all 5 people. If 1 or 2 will say similar things, then that's it. You can move on. But you've narrowed it down like that, and so it's important that you're clear about who you're interviewing and why you're interviewing them, and it really is useful to sort of whittle it down in that way. So next slide, please. Right, next poll, please. Yes, so it's as many as needed. So the point I made earlier about triangulation of evidence, quite often you'll interview one person, and then you might interview a few others, and you'll then find, well, actually, what I've now learned from these other people is that's inconsistent with what you told me previously. So you might need to send them further follow-up questions, or if there's actually quite a lot of important information that seems to be different, you might need to re-interview them. So you shouldn't get an idea that you only get one go at this. You need to do as many interviews as you need to. Right, so next slide, please. Right, another poll for you. So we're talking about investigation meetings here, not disciplinary meetings. Right, so the answer is there's no legal right to be accompanied at an investigation meeting. There's a legal right to be accompanied at a disciplinary meeting, but there's no legal right to be accompanied. Some organizations say you can never be accompanied because there's no legal right. We don't want anyone in who doesn't have a right to be there. Most organizations will have their own policy on it, and we tend to find, for instance, that public sector organizations tend to allow people to be accompanied at investigation meetings, and we see lots of schools allowing people to be accompanied by a work colleague or trade union rep at an investigation meeting, but there is no right to be accompanied. But I think also, even if there's no right at all, and we do see this, there's no right at all. But if someone, for example, has raised a grievance and they're feeling very sort of nervous or vulnerable, it may be that in order to get their evidence and in order to get them to cooperate, it may be sensible to allow someone to be accompanied at an investigation meeting. And sometimes organizations will even allow them to be, example, accompanied by their husband or wife, if that's what it's going to take to get their evidence. Right, so next slide, please. Right, so information gathering. So it's important as an investigator that you don't think that all you've got are the interview notes, because when I'm doing investigations, you're often asking people to recall things that have happened sometimes 2 or 3 years ago, and sometimes recall's not the best. If there's any documentary evidence, particularly emails that were sent on the day, so someone's had a difficult meeting with someone and they sent a follow-up email to say, look, I was unhappy about that, that is much better evidence usually than someone's recall 2 or 3 years later. So documentary evidence is really important. And I think also nowadays, documentary evidence, things like WhatsApps, someone sends a WhatsApp message. A lot of the most important evidence I find in my investigations are WhatsApps that are sent afterwards, or or nowadays people recording stuff on their phone. There's a situation at work and someone's done a video. So it's not just interviews. CCTV, Alice has mentioned this again. It's important that you make sure that any CCTV evidence isn't deleted, and internet evidence, again, that if you've got someone who's doing something, let's say inappropriate on a work computer, that you make sure that you coordinate that so that they don't get advance notice of the investigation, because what you don't want is everything to be deleted, although a lot of computers this day are backed up. But you've got to make sure that you're not going to lose important evidence. I did an investigation or a tribunal years ago for a very well-known household name company based in Germany, and they had a very strict data protection rule where all their emails were deleted after 6 months, which was wiped entirely. And that was a nightmare because we lost a lot of important stuff. So it's important that you're storing information where it's not going to be deleted. Next slide, please. Right. So you're the investigating officer. What do you do when someone says they want to raise a grievance? Yes. So 86% have said you go back to the person who did the investigation. I think that's the right answer, because you've got to. It's important about sort of, as an investigator, staying in your lane. You've been instructed to carry out an investigation. You've got the terms of reference. This is why the terms of reference are super important, because you think, well, does this fall within the terms of reference? And if it doesn't, then it's not your call whether you want to investigate it or not. And so you will go back to the person who's asked you to do the investigation, say, what do you want me to do about this? Now, often you will find, what you tend to find in this situation is the grievance is often effectively a beefed up, the counter grievance is often effectively a beefed up version of their response to the original grievance. So if someone is saying, so let's say a person has been accused of bullying. When you interview the alleged bully, they will say, well, actually, I'm not a bully, and actually the other person has been undermining me for years, and they're the real bully in this. And I want to raise a grievance now. I'm so annoyed about this, and I want to raise a grievance now about their bullying. Now, what you often find, obviously, as the investigation officer, it's not your call what you do about that, but what you often find is the person instructing you will say, well, it's so closely linked to your investigation that we're going to amend the terms of reference to include this counter grievance, because it would be artificial to end up with two separate investigations being done going over very similar ground. And actually that you as an organization, you're probably going to give yourself quite a few problems if you've got two separate investigations going on about that often the same facts, but just looked at from two different angles. And so you will often end up in practice then investigating that counter grievance. And what you'll then end up doing as an investigating officer is usually preparing two investigation reports into the two grievances, but there will be a core set of evidence that's common to both, but then you will end up with two separate grievance investigations being done. But given the overlap, there's it wouldn't really make much sense to do the same, to have two people do separate investigations. Next slide, please. Right, next question for you. So what do you do about the person asking for anonymity? Yeah, explore more. What's the problem with anonymous evidence? Well, the main problem is, well, there's two main problems. One is it's very difficult to make evidence anonymous. If I'm in a meeting, so I've witnessed two people arguing in a meeting, so two colleagues having a set to in a meeting, and I'm the only other person in the room, and I say I'd like my evidence to be anonymous. Well, it's obvious who I am, because I'm the only person there. So sometimes it's almost impossible to make the evidence anonymous. And the next point is that in order to make the evidence anonymous, you have to strip out so much detail that there's basically nothing left. You're left with this sort of blancmange of, where there's just nothing to it. So it's really important that you think, well, how am I going to make this evidence anonymous, even if I wanted to? And also, as the subject of the investigation, if they're faced with a lot of anonymous evidence, they may well fairly say, well, how can I respond to this? I don't really know, is this just a person who's got a grudge against me? Is there someone hiding behind anonymity because they just want to make trouble for me? Why can't I know this? How can I respond to this? Because I don't know where it's come from. It's too vague. And so it creates so many problems. I think a better approach with someone who wants to be anonymous is to find out why they want to be anonymous. And if it is because of fear of reprisals, the one I'm doing at the moment, there's quite a lot of fear of reprisal, and it's a bullying case. And that in itself tells you quite a lot of information. The number of people who want to be anonymous, who are nervous about being identified. So that in itself is quite important evidence. And it's usually better as an organization to make that person feel supported. So for me as an external investigator, I can't really give any reassurances, but what you would usually do as an organization is to say to that person, look, yeah, here are the details, or here's the contact details of, let's say, the chair of governors, the head, and if you have any concerns about any possible reprisals, then you must go straight to them. It's important that you're prepared to and happy to speak up and give your evidence and give your named evidence. But if there's any hint of any reprisals, then you must go straight to this person. And sometimes it's helpful to get that senior person to be in touch with them so they feel reassured. And I think there's a better way of doing it rather than saying, yes, you can be anonymous. So, but I think it's also worth exploring why they want to be anonymous, because as I've said, there is quite a lot of information there and useful evidence about why they want to be anonymous. So next slide, please. Right, so you've come to the end of your investigation. So then you'll set out your report. So the structure that we recommend for your report is to set out the allegation. So there might be, let's say, 5 allegations, 5 separate bits that you have been asked to look at. So what you do is you set out the allegation, you then set out under that the key evidence, the main evidence that you think is relevant to that particular allegation. So what typically we'll do is we'll have the report, and then we'll have the interview notes as the appendices, and then all the documents as appendices. So if the person who has instructed you, they may well end up reading all of the evidence, all of the interview notes, and all of the documents you've gathered. But your job as the investigator is to flag up and say, from my perspective, these are the most important relevant bits of evidence, and I'm appending them. So here's the relevant evidence. Here's the evidence that the person gave. Here's the evidence. Let's say it's a grievance. Here's the person the grievance raised. Here's the supporting evidence from other interviews, and this is the response from the subject to the investigation. And then you will analyze that evidence, and you will reach your conclusions on it. And so you might say, based on the evidence I saw, based on the way that the person answered the question, having triangulated the evidence, having cross-referred it, it seems on balance that that person's version was more credible. But you don't go any further than that. You don't arrive at any sort of conclusions on sanction or anything like that. But you might, as part of your job, say, just talk about whose evidence you found was the more persuasive. But the main job is to point up what the relevant evidence is in respect of each allegation, and you will do that for each allegation. So you don't tackle it in one big whole. You tease out the various strands. So you look at allegation by allegation, and then you consider the evidence in respect of each allegation, and you reach conclusions in respect of each allegation, and it must be done separately like that. So next slide, please. Right. So this is perhaps the most important slide of all. Your report, you need to contain all the evidence. I mentioned earlier the risk of preparing a report to support a particular conclusion. Sometimes you'll get someone senior saying, well, look, this person's always been a problem. Effectively, this is a chance to now get them out. And so there can be a risk of some pressure being applied to arrive at a particular conclusion, find evidence to support a particular conclusion. You must, as an investigator, you must resist that pressure, which can be difficult, but you need to say, well, you need to be led where the evidence takes you. And it may be, for instance, that you will say, well, actually, what I've uncovered is this was a common practice, and there seems to be lots of people who don't follow the policy, or there seems to be a lack of training in this area. So actually, what I've uncovered is a systematic problem, rather than this is just this one person doing this. So I'll tackle the questions at the end. So so it's important that you are considering all the evidence, and you're not seeking to find evidence to support a particular conclusion. And the next one, I think I'm just about to answer the question I've seen flash up. You don't consider the sanction. So you won't say, well, actually, I think this this is something that where it should go as a disciplinary, and yeah, I think this is probably final written warning territory. I see lots of investigation reports where that's being done, or I think this is worthy of dismissal. You know, that is a step too far. You're, as the investigator, it's a binary decision. If you're doing a disciplinary case, you will say, I think there's enough evidence here to justify going that this should be taken forward as a disciplinary hearing, full stop. You don't go beyond that. And with a grievance investigation, there can be a temptation to say, well, actually, I think this part of the grievance should be upheld. Again, that's a step too far. As an investigation officer, what you can say is there seems to be evidence to support these bits of the grievance, but over to you, Mr. Decision Maker, because usually in a grievance process, what happens is it will say that the grievance is raised, an investigation may be done, and then there will be a grievance hearing. So it will have this sort of grievance hearing person, and they will consider the report. The employee might have a chance to make any further sort of submissions, and then a decision. The decision gets made at that grievance hearing, not by the person investigating the grievance. So it's important that you maintain that distinction between the two roles, and you don't stray into upholding bits of the grievance or deciding on any disciplinary sanction. Next slide, please. So when you are looking at and this also sort of is good advice for the person doing a disciplinary hearing, you need to look at, in terms of deciding, is there enough evidence here to justify this? You need to think, well, is this actually a breach of our own, any particular policies or codes of practice? And it's important to think about precedents. By precedents, I mean, how have similar episodes been dealt with in the organization previously? But also, I did when I was an employment lawyer, I did a case for it was a train company, and in the yard where the trains get cleaned and repaired, there used to be people sort of going through these going through red lights in the shed, and occasionally the trains would fall off the rails, all at low speed, but have to be craned back on. It cost everyone a fortune to sort out. And so, but this happened quite regularly, and the organization sent around a memo and said, from now on, anyone who does this is, this is going to be a disciplinary matter. We can't have these trains falling off the rails. And so, whilst there was one precedent for what had happened previously, if any instructions have been given, say, and this memo was very helpful, it was all in bold saying this is stopping from today, it's important that you take into consideration that is, have any clear instructions being given where you can say, actually, based on that instruction or that email, is this something that appears to be a breach of the instruction or a particular code of practice? It's also worth thinking about burden of proof. Just remind yourself that you are working in the civil context. You are not the police. You are not trying to prove things beyond reasonable doubt. It's on the civil burden is on the balance of probabilities. So it's more likely than not that something has happened. So the burden of proof is much lower than for than in criminal cases. And HR's role. So HR can be very useful for helping with things like precedents, because they will probably have a better idea than you of how similar cases have been dealt with in the past, and what they'd be able to point out policies and codes of practice. But it's important that HR's role doesn't extend too far, because there's a very sort of well-known case. It's called Ramphal, and in that case, this was a disciplinary case. A manager had decided that they thought that the particular issue only merited a final written warning. The HR head of HR then persuaded them to actually turn it into a gross misconduct dismissal. And so that happened. And so the manager then was persuaded by HR, and they dismissed. The person took them to employment tribunal, and they lost. The reason so it was not, so it was held to be an unfair. The employer lost. It was an unfair dismissal. The reason it was an unfair dismissal was it wasn't the manager's decision. It was HR's decision. And the other sort of bit about that is any communications between HR and managers, they are not privileged. They are not legally privileged, which means that the employment tribunal got to see all of that communication from the HR manager to the manager saying, well, actually, I think we should go for dismissal here. So it's important that HR are a very useful resource for help with things like precedents, but ultimately any decisions must be made by the manager, the investigating officer, and the investigating officer alone, and don't be sort of persuaded in the level of decision by HR. So next slide, please. So the next bit, when you've done your report, you will submit your report, and just that, by which I mean you will send your report in with all the appendices, and hopefully nicely cross-referenced with page references, so you can quickly dig out the relevant bits. But I think also, just on a practical point, you should retain the report, because what you'll have done is you'll have gathered together probably hundreds of bits of paper, hundreds of documents, various interview notes, various policies. Keep it all in one place. So you might have a physical copy and also a sort of a PDF copy, because what you don't want is, in a few weeks or months' time, if someone decides to progress with, let's say, a disciplinary, or ends up in an employment tribunal, you don't want someone to have to then sort of re-find everything. So just on a practical step, just try and make sure that you keep it all in one place. So next slide, please. Right, questions. So I rudely scampered through a lot of your your questions. Right, so sequence, I think I've dealt with that. Yes, so Catherine's question: investigation officer shouldn't form a, they can form a view, yes, and I think that is perfectly acceptable. In fact, that is the investigator doing their job. Yes, so you've got to avoid, there's sort of there's a sort of tension between having a very vanilla report where you literally say, right, here's all the evidence, over to you, and the other end of the spectrum is saying, and here's some opinions, and this is what you should do, and this should be the disciplinary outcome. So there's a sort of a spectrum there, and a good investigation is somewhere in the middle of that spectrum. So you analyze the evidence, you've heard the people, you've sat in front of them, and you formed a view of what you think is the most persuasive evidence. And I think it's perfectly fine to flag that up. Right. Okay. So that's AI transcription services. I think the answer is I've tried them, and there's none I can recommend. I've got to say, we use the Teams. I used the Teams one once because our note taker went off sick, and it was one of the worst sort of 3 hours of my life trying to put the Teams transcript back into actual English. Yes, so I don't have any recommendations. We are trying ones at the moment, but none of them have been brilliant yet, unfortunately. But I think they're only going to improve. I still favour having a good note taker. The other thing about notes is the notes should be a good note should be a an accurate summary. You shouldn't try and catch it verbatim. It's sort of an accurate summary, I think, is the best sort of note. Because the thing with transcripts is they're very bitty. In normal conversations, people interrupt each other, and it's very difficult to follow a transcript. But having a good note where it's sort of a summary, an accurate summary of what's said, I think is much better. It flows better, much easier to read. But what we always do at the end is we will send those notes. The way we do it is the note taker will take the notes, they will tidy them up, get rid of all the typos, etc. Check their names in them, and then send them to me. I will review them. I will then send them to the person I've interviewed and say, look, I think these are accurate, but if there's any amendments you want to make, do them as track changes just to the accuracy. But I also say, well, and if you've had any further thoughts, you can add those in at the end if there's any sort of further observations, because sometimes you might trigger some memories and things that have cropped up. So I think that is a valid thing to do as well. Right, so let's move on to Dave's one. Email. Is a mechanism of recording the statements. I don't. Sorry, do you mean? We tend to do the statements in Word. We don't. Yeah, I think emails can be difficult to read and format.
Can I say something? Sorry.
Yes.
I've just done a couple of complaints or investigations into complaints, but I've had to do them from a distance.
Yeah.
For geographical and travel reasons, and therefore email seemed a decent vehicle. But I was just wondering whether there were any technicalities around the legalities of that, or
no, I mean, there's no issues around the legality. It's just, I think the problem with
Simon, shall I pick that up with the parent pupil stuff?
Sure.
If it's about, I'm assuming it's a parent pupil complaint.
Yes.
That you've been dealing with. So Dave,
fine.
I'll pick that up later.
Thank you.
Thanks.
When you say there's a need to try and the one word against another is, there's just a risk that it can be just a sort of a cop out, because as I've said, the quite often in bullying situations, people who are bullies or sexually harassing will do it deliberately in a situation where there's no witnesses. And so effectively, if they know that it's only ever going to be one word against another, and therefore no conclusions can be reached, no findings can be reached, that's sort of giving a free pass to bullies. And so you need to do more than that. And so you need to, given that you are not the police and you don't have to do things beyond reasonable doubt, it is acceptable to arrive at conclusions based on the evidence, based on who you think is more credible when you're interviewing them. Because you might think, well, you can also bring into account the credibility generally. If there are inconsistencies in their evidence, then it's perfectly fine to say that. I mean, for example, when I'm doing lengthy interviews, I will often return to the same question several times, get in different versions deliberately. So sometimes they might say to me, well, I can't remember. And then the next time they said, no, I didn't do that. Well, they're different answers. They're both versions, but they're different answers. And so you will go back to them and say, well, hold on. And this is something that often only comes out when you finish the interview and you're reading through the notes and 20 odd pages of notes. I've done one recently, it's 110 pages of notes. So you can't keep that all in your mind in one go. And so you might go back and say, well, hold on. There you said you couldn't answer, but half an hour later you said you definitely didn't do it. And so they are different. So can you help me understand the difference there? And so I think that, and if one person's evidence is consistent and there's lots of detail, and the other person is giving inconsistent evidence and evasive answers, then I think you can say, well, based on their responses to me, I preferred that their evidence seemed to be more persuasive. Cheryl's asked, is it okay to ask not others on the others not on the list? Yes, it is, but you should go back to the people instructing you, and particularly in our job, you know, where we are sort of we're being paid by the day, as it were. It's not in our gift to just say yes, we're just going to crack on and interview these other people. But yes, if having interviewed them, it's apparent that you need to cross-reference some information that you've been given, and the only other people who can do it are other interviews, then yes, I would go back to the person instructing me and say, yes, it's I think I need to interview this person. And in fact, I've got a call this afternoon on exactly that, where I'm going back to the person instructing me and saying, look, this is now cropped up. I think I need to interview these other people. Can you interview on a subject matter? Yes, I think you can. If you need sort of expert evidence, again, if the person instructing you is happy for you to do it, then yes, I think you can go and get some expert evidence on that. I had to do one on sheep farming rights, and so yes, I'm not an expert on sheep farming rights, so I sort of had to go and get some expert evidence on sheep farming rights. Off the record, that is Catherine's question. That is a really tricky one. I think what you need to say is, what you're telling me is on the record. You know, you've got to avoid finding yourself in a situation where you've agreed and you've heard things that are off the record, because if it's important evidence, then that puts you in a difficult position as an investigator. Hopefully, we read out at the start of our interviews, you know, what you tell us is going to be sort of taken down and used in evidence. And so I think if someone starts saying, I want this off the record, I think you need to have a conversation before they tell you it, because you don't want to find yourself in a position where you're holding on to important evidence that you don't want to find yourself drawn into that. I think Christian's one I've sort of answered. Does a conclusion include whether substantiated? I think I would sort of stop short of substantiated. I think that's the decision for a decision maker, you know, at a disciplinary hearing. But I think you can talk about whether you found evidence persuasive or not. Any particular specifics regarding notice? Now, again, it depends on your policy. My preference is to not give people too much advance notice of interviews, because you don't want people to prepare too much, and you often end up in a situation, particularly with people who are supported by their union. They will say, well, we need, you know, all the evidence in advance, tell us exactly what we're being told. And there's no right to that unless your policy allows that. This is an investigation meeting. It's a very different set of rules than for disciplinary hearings. Disciplinary hearings, yes, all the evidence needs to be given in advance so people have time to prepare and consider their responses. But this is an investigation meeting. This is very different. And so I would suggest that unless your policy requires it, that you wouldn't share much information up front. I think that's got to the end of the questions, and look at that, 11:14. So yes, so the break starts. We're having a break now, and then after that, it's over to Tabitha. So
yeah, so we've got a break now until 11:30. If everybody would like to go and have a comfort break, fill up on caffeine, do what you need to, and then we'll come back and talk about pupil and parent investigations, and then finish with some top tips about those before another round of Q&A, and end at 12:30. If anyone's got any particular questions they want to make sure that I think about, pop them in the chat now and I will make sure they're covered. Thanks, everyone. I'm going to continue with pupil investigations, and thanks very much for some feedback and questions on things you'd like to have covered. The reason we follow the general comments that Alice has made on commissioning investigations and those that are done in relation to the employment sphere with a specific section on pupil investigations is that they are very different. Some of you have already identified that with reference to the questions that have been asked, but the legal framework and the requirements and what is, in inverted commas, the right thing to do can vary markedly. So I want to start by moving from the employment sphere to thinking about the sort of pupil investigations you'll be doing. So it might be pupil disciplinary matters. We see a lot of matters involving bullying and drug use, but there can be all sorts of other things. There can be safeguarding concerns or allegations relating to pupils, which will involve not only the behaviour management team, but also the safeguarding team, and often both, with different aspects of what's going on. They often extend to issues around SEND as well. And in particular for the boarding schools among you, where you are required to have a pupil complaints policy, but more broadly, you may be looking into complaints that have been made by pupils who want a response. Tamar, on to the next slide, please. The legal framework is slightly different. Many of you will be charities, and what is required is that the trustees ensure that action is taken which is in the best interests of the charity, and we always have to have that in mind. We'll then have to think about the education law framework. Everybody on this call will be used to the independent school standards and the guidance on that. And some may be also thinking about national minimum standards for boarding and the early years requirements. All will be familiar with the safeguarding guidance. You would think, wouldn't you, that there would be some express content on investigations and how they are conducted within those. There's very little guidance. What I can say is that there used to be none at all. There is at least some now, and there is a piece of advice within Keeping Children Safe, which isn't mandatory, but which recommends that schools think about the involvement of independents, the more serious the allegation or issue is that you are investigating. Then you've got the parent contract, obviously for those independent schools among you, and the parent contract will set out in detail exactly what you say that you as a school will do. But there are some implied terms in addition to those which are set down, and those are that you will exercise any discretions you have in a reasonable and lawful manner, and with procedural fairness, particularly where the status of the pupil is at issue. And that might be in behavioural grounds, so it might be that you're considering a suspension or a required removal, or indeed an expulsion. It might be because you are undertaking a risk assessment process and actually thinking that you can't safely have a child there and a termination of the contract. And it might be actually because the status of the pupil is at issue because of the conduct of parents. So worth thinking about those things. And although public law doesn't normally apply directly to independent schools, and it will for those academies among you, essentially it is a threshold of reasonableness and fairness which we should all be meeting in the mechanisms that we use to commission and conduct investigations within a school. So worth thinking about. Then we have to think about our duty to take reasonable care in negligence. That's a duty to take reasonable care in all of the circumstances. And when a court retrospectively takes a look at whether that duty was discharged, normally in response to some sort of claim for compensation, they will look at what is usual in your sector, and they will look at the guidance, whether it's statutory guidance and mandatory for you to think about it, or non-statutory guidance and a useful resource for schools. So we need to think about those things. We need to think about the particular and very prescriptive guidance for academies and maintained schools on suspensions and permanent exclusions, and the circumstances in which you can do that. When we're thinking, for example, on the situation where you may think it's unsafe for a child to remain in school while you investigate. So that needs to be borne in mind. Independents tend to have a bit more flexibility about those things. And then, of course, the school policies and procedures, forgive my shorthand there. And it's always worth thinking about that, because what you find when you're dealing with pupil matters is that things don't happen in nice straight lines. You don't have a single issue that comes across your desk that needs to be thought about. It tends to involve lots of different pieces of the framework that we've set out. And what you may find when you start pulling all of those strands together is that some of them are inconsistent, and you then have to decide what is the right thing to do in that context. And most schools will undertake reviews of terminology and policies and procedures on a rolling basis. So there may be some internal inconsistency within those that you need to bear in mind. So it is complex. We're going to move on to the next slide. And just have a little bit more thought about what is meant by procedural fairness. So essentially, it is where it is made in accordance with statute and the legal framework that we've talked about before, but also with the requirements of natural justice. And I've set out the test there so that you have that to hand. Essentially, I think it will all make perfect sense to you all. It is that the person who is making the decision must be impartial, so unconflicted, and can't have prejudged. And that, of course, involves real care in the way that matters are commissioned, so that it isn't the situation which we would sometimes see, where someone says, this really is the last straw, go off and investigate that so we can get a child out, or so-and-so's done that again, can you please go and report back? So think about that in the context of both the commissioning and conduct of your investigation. And then think about what it means about the liaison you have with the pupil who is being considered, particularly on a behavioural disciplinary basis. So if they may be adversely affected, if a sanction may be imposed, they should receive sufficient detail of what they are alleged to have done, and detail about the evidence that there is, and proper notice to have some time to think about it, to be given an opportunity to present their case before a decision being made. And when you're talking about pupils, in particular, it's those longer term suspensions and exclusions, and school processes are set up in such a way that there is usually a disciplinary meeting. So there's an investigation of the facts, and then there is a disciplinary meeting where they have an opportunity to make representations on the findings and on appropriate sanction before a decision is made. But it is worth thinking about, just in the context of ordinarily doing your investigation, because it isn't just a matter of when you are speaking to a child, tell me what happened, give me your side of the story. If there is the potential for disciplinary action to be taken, then you do need to think about giving them that level of detail to be able to respond appropriately. And what that will mean in many cases is potentially having more than one meeting where you are going back to the person about whom an allegation has been made, summarising the evidence that you've collected from others and giving them an opportunity to respond. So if we can then move on to the next slide, please. So far, so normal. You'll say, yes, we've heard much of this already in relation to employment investigations. So what I would like to do is just say, what's the difference then? Lots of similarities, as I've put on the slide. The differences are that it's not as prescriptive when you're dealing with a pupil investigation, and that there's much more scope with pupil investigations to take a proportionate response. And that I think is important. There's also much more scope to, if you like, blend the various roles that very clearly have to be differentiated when you're dealing with employment investigations. And you don't always need to have the detailed reports and written statements and other things that you would have in an employment investigation. So a bit of good news that you can, when you're dealing with these, think quite carefully about what is required and your methodology in terms of dealing with it. But what I would say is I really would reinforce the message that you've got from this session already, that it's sensible to think very carefully about commissioning an investigation and the conduct of it. So that the person who says this needs to be investigated goes on to either direct themselves or to instruct someone else about what is required and how, and thinks then about that differentiation of roles, so that you're flagging right at the get-go whether the person who is commissioning the investigation is the right person to be doing so, and you're thinking about conflicts and process from the beginning. And what I often see in relation to pupil investigations, because there is a need to be swift and proportionate, is people launch straight into the investigation without necessarily stopping to think, is there anything else that I need to be thinking about in this context? So if you can have that pause to think about it in that two-stage way, I would thoroughly recommend that you do. And the next slide, please. I know that Alice talked about police involvement in investigations where you had employment investigations being considered. Similarly, you will need to think about it in pupil matters. So commonly where there is a disciplinary matter which has been reported to the police, you need to be very clear about what you can and can't do in the context of investigating matters yourself, and or in risk assessing what arrangements you're going to be making so that you can work out whether there are any control measures for that pupil to remain in school, for example. So the best way to deal with that is to speak to the police and seek express permission to investigate in some ways and to set any parameters. And until then, to act on the basis that the allegations may or may not be true, insofar as you're thinking about the wider pastoral response. What a lot of people ask me is, well, if we think something, may be a criminal offence, do we have an obligation to tell the police, to ourselves report it to the police? And there's some conflicting guidance in all of that. Essentially, for me, I would consult the two different pieces of guidance that I've referred to there. There's the NPCC guidance on when to call the police. And then you've got the charity guidance for those of you who are charities, which gives some useful information. Essentially, it's a best interests test. So you're always going to be putting pupils at the front and centre of what you're doing, and you're balancing the impact on the person or people that you are reporting against your wider school community. What I don't think you need to do is yourselves spend a long time analysing the criminal law and the requirements in order to determine whether it is a criminal offence or not. And commonly what we will see is situations where matters have already been taken to the police, often by aggrieved parents. So worth thinking about that, and when, as I said, the police are involved, liaising with them about what you can and should be doing. Next, we've got here is about whether pupils should be suspended pending investigation. And this is going to depend on the type of school and the type of situation, and will often depend on matters such as maintenance of the evidence, protection of evidence, and on safety of the person involved and of the school community. I often think with all of these things that it's worth reaching out and seeking advice from children's social care. I think even if they don't respond, I think as part of your broader risk management response, it can be useful to say that you've spoken to the police or children's social care in these things about how matters should be conducted at a time when matters are highly sensitive and pressured for everybody involved. And also make sure that where you can, you've spoken to the victim and ascertained their wishes and feelings, as that's going to be one of the crucial considerations that you will have in deciding whether or not to report to the police, albeit it's not determinative. Thank you, Tamar. On to the next slide, please. So when you're commissioning, think about I say policy, but it is more commonly the policies which apply to the situation. And then think about who's the decision maker and whether they can or should delegate the investigation. Often you may say it's much faster, more efficient, more appropriate in a pupil scenario for the same person to investigate and determine, because they've heard all of the evidence and they can make a sensible conclusion about what happened and what should be imposed by way of sanction in a disciplinary situation in that way. But do make sure, as I said, that the commissioner of the investigation is unconflicted and that they can fairly do that. So it's worth thinking about that two-stage piece with that in mind, and also think about capacity. Schools are busy places, and you've got so many hats to wear and so much to do in the normal day job that when you have an investigation to do on top of that, capacity can get strained. And when you have pupils at the end of all of this, you want things to be done quickly. What we're seeing over time is increasingly schools building up extra resource so that there is someone centrally who can potentially undertake these sort of investigations in order to try and reduce time lag. So that is something that some schools are thinking about. And then if you don't have capacity or otherwise, you should think about whether the investigation can and should be conducted internally. As I said to you, in most cases, the situation will be that your policies and procedures will allow you to conduct it internally, subject to concluding that there are no pertinent conflicts of interest. But you may decide either presentationally or on capacity grounds that you want it to be undertaken either by an external body or entirely independently. And just referring you back to what we said in Keeping Children Safe about the more serious matters and about independence. I find they're particularly useful where you've got a situation where people are complaining about you being biased, the school being biased by one towards another, or where they say there is a systemic issue. It can be really useful in those cases in particular to think about independence of investigation. And also think about whether it may be helpful to seek advice or consult on process. I've said some of that advice may be about the police or the local authority. It may be touching base with us. And the consultation on process may be in those sort of situations where your policies and procedures don't all neatly align in terms of timetable or in terms of different options perhaps for the way in which things are looked into. And sometimes the best way to deal with that is to deal with it with a straight bat, to tell pupils and parents that that's the case, and to negotiate or consult on a proposed change to the set process. If we move on to the next one, and I know timing was something which, timing and sequencing was something which is about which questions have been raised. Tamar, if you could move to the next slide, please. Then you do need to think about expected timings. What is expected, but also what's realistic given what's involved. Often I say, do think about where you are in the school year. Many policies will say that investigations don't need to be conducted over the holidays. But actually what you may find is that it really is in everybody's best interests for it to be rushed through or to be dealt with in the early bit of the holiday, so that everybody knows where there are, if there may be significant impacts on a child, particularly where you're reaching the end of an academic year and a natural break. Think about other things that the investigation might impact. I've listed a few on the slide, but there may be others that you'll want to be thinking about. I've said, is there a concurrent subject access request? We're seeing so many of these. I've never known someone make a subject access request or other request for information solely because they are interested in seeing what's been written. They are most always made in the context of some sort of dispute. And then you're going to be thinking in timing terms about whether you deal with an investigation before people have the records, or whether you should wait for all of the records to be available and picking matters up once the subject access request is there. So there's no hard and fast rules on those, but worth thinking about, and worth also thinking realistically about whether there is part of the subject access request related to the investigation that could be expedited to help you through all of that. Think about whether there are other related investigations. So it may be that there is a local authority review or assessment. It may be that there is litigation. It may be, as we talked about a police process. And you do need to be very clear about what you're doing and why, and whether you have the right permissions in that context. And as we said before, resourcing is really important with all of that. One of the questions that was asked before I move on in terms of timing was in relation to sequencing, and I'll pick that one up as we go through about the conduct of these investigations. So the next slide, please. So terms of reference, no prescribed format, but I do think it's really helpful to have some form of audit trail, and the extent of detail, the scope and the amount of detail that you put in your terms of reference is going to vary depending on whether it's being done internally or externally, and on the seriousness of the issue which is being thought about, and the sensitivity of the information that's there. But it's useful to make sure that everybody who is involved is clear about who's doing what, and for who, what information they will be given or can request, what's required, what you're expecting of them in terms of outputs, and as we said before, what when you're talking about the outputs, that might be, I just want to know what happened. It might be, I want to know what happened and whether it was a breach of expected standards of behaviour, or it might be as akin to an employment situation where the investigation is a starting point and you are moving things then for a disciplinary hearing to be undertaken usually by the head. So on to the next slide, please. So now we've moved from commissioning to what your investigator is going to do in the knowledge that it may be the same person. And in order to ensure that there is no conflict, and that there is a fair, balanced and proportionate process. And prior planning and preparation is absolutely recommended in these situations, particularly in the more serious matters. And one of the things that is quite often forgotten in all of this is whether people have expressed a view about process, and that might be the victim and it might be relevant agencies. So just as an example in relation to that, you might have a situation which is something which could be a criminal offence, and where a victim says, I don't want to involve the police, but the school then is asked to investigate matters, and you have a decision about whether you can and should investigate yourselves or not. So that's particularly common in the child-on-child abuse scenario where those things happen. And think about whether you need to tell anyone before you start, especially parents, in the knowledge that if you tell parents before you start, they are very likely to want to then be involved and, as someone mentioned in the chat, to want to support their child through. And often those things will depend on the seriousness of the issue that is being investigated, and indeed on whether it's confidential to those in school, or whether it can and should be shared with parents. The next slide, please. So in a similar way, I'm going to recommend that you start with thinking about what you know, what's been alleged, thinking about the relevant expected standards set out within the school. Sometimes you'll find that you've got an allegation where it doesn't fall squarely between what is set out in policies and procedures, and I will quite often in those cases look back to the sort of general expectations in terms of vision and values, which can be useful in terms of looking at those aspects. And then think about what evidence is already available and what you need to preserve, and that can be in relation to IT aspects, but can be otherwise. Then you need to think about searches, and that can be searches of pupils, of devices, of belongings, and the arrangements for this. Is the person who is proposing to investigate somebody who is authorised to conduct those? Have you made sure that you're following your policies and procedures in that way? And are you thinking about the sequencing in all of that and the orders in which you're going to speak to people? Then you may be thinking about your witnesses and whether you're going to start with members of staff, whether you're going to start with third parties or pupils. People will often say to me, well, we're a school, so we can't speak to anybody outside the school community. And that's not a given. You can speak to anybody you would like. Whether they are willing to be involved is a different matter, but you can reach out to them. And you'll want to think about how best to elicit the required information, balancing things like the risks of collusion. And I just wanted to pick up on what was said earlier about emails. So often in the pupil investigation scenario, people will sit everybody down and say to everyone, can you write out a statement, or indeed, can you email me your version of what happened? I think the issue in relation to pupil investigations is that what you get from that first response will often need to be teased out when in more detail. So don't assume that because you've got statements from everybody who was around at the time, in that you ask them to write down what happened, that will necessarily be enough. It may need to be supplemented, and you may need to speak to them to say, oh, that's interesting you say this, because this is what has been reported elsewhere, or I noticed that you haven't dealt with any of the previous history. What can you tell me about that? So think about those things. In terms of pupils being accompanied, I know that many times arrangements will be made. Pupils can be accompanied, and many times there will be requests for parents to be the one to accompany the child. And what I always say is that I would recommend that even if it's not mandated in your policy, you consider it. You consider it on the basis that if it's very serious, it is a way of demonstrating that you're going through appropriate process, and it may be a reasonable adjustment for that child, particularly if they are requesting that their parents attend. In a similar way to what Simon has said, think about recording meetings or noting the outcome and who should be doing that. And again, that's going to depend on the severity of the issue and available resource. And bear in mind, please, that even if people are told that they shouldn't be recording things on phones and other devices, they often do. I have to say that in my experience on the litigated matters, where they do, if it is the recording is germane, it's often admissible later. So you may want, as part of all of this, to be giving some clear guidance about recordings, so that everybody is up front. And as Simon has already said, do look for and record evidence that both supports and contradicts the facts alleged, and put it to the witnesses. So it is very rare that all of the witnesses to an event are wholly consistent, and you do need to tease those inconsistencies out. And if we can go on then to the next slide, please. I wanted to pick up on a couple of particular issues in relation to pupil investigations. One is about bullying and whether it requires intention. And the reason I do that is that I look at an awful lot of bullying investigations in the context of what I do, and I very rarely see people reach a conclusion of whether or not the action was intended or reckless as to whether it hurt or upset a victim. And often I will see people saying that it can't be bullying because it was only a single incident. So in the bullying situation, I would recommend that you always think about asking about the bigger picture rather than dealing with matters as one, and that you do think about intention, and you ask the question and think about whether it can be inferred by an element of planning or by what this person has said either on social media or to others about what then happened, or about what the likely consequences were of their actions in that sort of context. Next slide, please, in terms of send. So I often will hear the parents of pupils with special educational need or disability say a school can't sanction that child. Now, I hope everyone on this call will know that that's not true, but you do need to make reasonable adjustments. And when you're dealing with your investigation, you need to be thinking about whether there are adjustments that need to happen to usual process for that child, but you will also be thinking about exploring whether what that child is alleged to have done may be a manifestation of their disability. So these are things which will often involve consideration of what's known about the child and their needs, and worth thinking about in relation to all of this. And of course, once the investigation, if it's a behavioural one, has been concluded, then you'll be thinking about it all over again when it comes to appropriate sanction. Next slide, please. So next, I just wanted to talk about, no, it's the one before, thank you, Tamar, credibility. So I will often hear members of staff at a school who've been tasked with investigating saying, well, it's not substantiated on the basis that there's no corroborative evidence. One saying one thing, one saying the other. There's no, no independent witness. And I say, well, actually, when you're doing an investigation in a similar way to what Simon has done, you're entitled to balance the evidence for and against, and you may make a finding that the matter is substantiated on the basis of other evidence available to you. And that might be about corroboration. It might be about motivation and allegiances of those you've spoken to. It might be about how consistent someone is about what they've said. the language that they've used in the way that Simon talked to you about, how long after the matter the issue was raised, and more broadly about their previous history. And if you are making findings where it's disputed, it can be useful to think about that list to document your reasons for preferring one person's essentially description of what happened over another. Next slide, please. I also think it's worth thinking about relevant factors. In a safeguarding situation, you will be thinking about seriousness, and in a behavioural one, you will too. And I often find in a behavioural situation that it could be really useful to think about aggravating and mitigating factors. And I'll quite often go to the Sentencing Council's guidelines for criminal offences, because they quite often, for the different sort of matter that's been done, will specify some aggravating and mitigating factors that it can be useful for you to make sure you build into your investigation report. And there are a number that are listed there, which are hopefully helpful for you all. Next slide, please. So then you need to reach findings. You need to be very clear about what you've been asked to do and to then apply it. And when you're thinking about the facts, what you are well, hopefully going to be able to do is to say, well, this is what I think is likely to have happened. These are the disputed factors. This is what I think is likely to have happened from those. And there may be some situations where you say, the evidence is disputed on that, and I'm not able to prefer one version's events over another's. I can't reach a finding on the balance of probabilities, so that's unsubstantiated. More broadly, once you've reached the factual findings, you then need to move on to think about other things, if indeed you as investigator have been asked to do that. So whether there's been the breach of expected standards, whether you were asked to impose a sanction, and to deal with those matters. In behavioural terms, I am commonly called by someone who'll say, there's been an incident and we're proposing to suspend. And I'll say, what did you find happened? And people don't break down the difference between the findings and the sanction. And it can be really useful to always think, okay, well, what are my findings in relation to that? And be very clear about that. So I had one this morning where I was talking yesterday about an incident in a classroom where a child had been essentially defiant and standing in the way, and somebody went to just sort of sweep them aside without force, and they had slammed the other person against the wall. And I heard that yesterday and then barged past a teacher. Today I was told, oh, and they kicked another pupil at the same time. And I was a bit like, well, was that a finding or was that an allegation? And was that investigated yesterday? And if not, do we need to go back and think about that too before we move on to the disciplinary? So just that real need for process there, please. And then the next one, please. So in writing up an investigation, think about what is required. Often in a school, you need to have a note, but it doesn't need to be a report. It certainly doesn't need to append everything, but there are some processes that will say, yes, you need to take statements and keep records. So you'll need to think about that. You'll also need to think about the extent to which your report names those involved, in particular other pupils, and for what purposes it might be used, such that you may want to be using ciphers or other anonymity. So it's always useful to think about those and be mindful, as ever, of the possibility of a subject access request. Next slide, please. I haven't spent a long time today dealing with parental investigations, but all of the same matters, factors will need to be thought about in the context of parental complaints. I deal with a lot of those and help schools with them. I'm very happy to answer questions or stay on afterwards if anyone's got any particular concerns. I guess the thing that I see schools getting in a pickle about with parental investigations are, first of all, understanding that the complaint is often about the failure to investigate something properly earlier on. And a complaint investigation doesn't mean that you're necessarily going to go in and do the investigation all over again. What you're doing as part of the parental complaint is essentially a review of what was done in order to decide whether it was appropriate or not, and then to think about, make recommendations about what should be done as a consequence. So that would be one. And the other one that we commonly see are around safeguarding referrals for a child where a parent learns of it and is very unhappy that that was that was done, and seeks to complain about those sort of aspects. But all the same principles will apply to dealing with those. And if we move on to the next slide, I think all of the tips will apply to both too. So in my advice would be to make sure that you do inform people as soon as you can of the need to investigate. And I think it can be fine to say, this is something which we think needs to be investigated. We do need to consider process carefully to make sure that it's fair to everyone involved. We'll let you know how that's going to be progressed as soon as we can. I think it can be as little as that. Make sure you support everybody involved. It's horrid having a complaint against you. We all know that. And so, yes, of course, we need to lean into the person who's complaining, but we also need to support everyone else affected. It's horrid being in trouble at school, and in a similar way, we need to do that. We need to manage expectations, but real life often gets in the way of best intentions. So it's a question of maintaining communication such that if matters change, you tell people, and rather than simply don't give an update and disappoint, that at least you can show those involved or those who inspect you what you've done to try and be clear. Always think about fair and proportionate responses, and always think about pragmatism too, so that if policies and procedures that are set out are inconsistent, that you try and be pragmatic about that and think about appropriate alternatives, albeit that you will need to think about your regulatory obligations in all of that. Then you've got about scope creep. And this is particularly common in the parental complaints sphere. where something starts off as a complaint, and then as the complaints process goes through, you have more and more things being added. And essentially what you would want is for that to be carefully managed, such that you make a decision about whether to admit it and investigate that too or not. So it's about identifying what scope is. Think about what you write down for all of the reasons we've spoken about. And if you take external advice and support, make a note. Even if you don't get a response, make a note that you asked for it. For any of you who work with me, you know that I love a chronology where I record what happened and what you've decided, and the communications about the investigation, as well as the investigation itself, because it helps you to demonstrate that fairness that we were talking about if you're challenged, and make sure that things don't get lost along the way. So it's absolutely something I would recommend. And don't forget to inform those involved in the issue you were investigating of the outcome where you can. And I know that often people will say, oh, we're not allowed to talk about disciplinary matters. But if people have informed you, have brought a matter to your attention, or have participated in a process, even if it's just to say that process has concluded and action has been taken, it's very powerful to show that they've been appreciated in what you're doing. And that matters are concluded. Okay, Tamar, onto the question slide, and I can see that there are some, so bear with me while I have a look at those. We talked about allowing parents to attend, and there was another question which I will hand over actually to Simon and Alice. So following on from the question about parents attending a pupil investigation where the matter relates to their child, what happens about a pupil being involved in a staff investigation, and who should be there with the child if that happens?
I can answer that. So I think it's important that the evidence is credible, particularly if the member of staff is going to potentially be disciplined or even lose their job as a result. So you do need to think about how you gather evidence from the children. Ideally, that needs to be done quickly. They need to be separated out and not, you need to reduce the amount of time for collaboration. I would absolutely recommend that they have a neutral adult there. That may be a tutor or a house parent or somebody appropriate. It doesn't need to be their parent. You may get parents saying they wanted to support their child when children come back and say that they've been interviewed, and it does depend probably on the nature of the allegation as to whether you would take some time to accommodate that or think about it. So circumstances may dictate that that's appropriate, but otherwise doing it quickly with an appropriate adult present is the right thing to do.
Thanks, Alice. Then there's a question in the pupil context about the reasons for separating an investigator and a decision maker. And essentially, it's meant to be a question of fairness, and you are more likely to do that where someone's place is at risk. So often, for example, where you're talking about a behavioural matter involving a child, the head will delegate the investigation of the issue, and then have a report presented, which they then consider separately in the broader context to determine appropriate sanction. It is about fairness and about a sort of second sight and checking that the evidence stacks up in relation to those things. It isn't required, and what most school policies will do is, as I say, not require the distinction in both roles unless a pupil's place is at risk, and then have a disciplinary meeting where it's a suspension of a significant time or a permanent exclusion. The next comment we had was about LADOs wanting to know whether something is substantiated or unsubstantiated. And absolutely, I endorse that. I get asked this question a lot. You will know in keeping children safe, if there is an allegation against a member of staff, you have a range of options available to you in which they include those sort of things. But essentially, I think it's good practice that you do adopt those where you're talking about pupil matters too. And we will commonly be told that allegations against a child are false or malicious, and if you are already thinking that you're aiming to come up with some sort of descriptors that fall in that line, then that will be very helpful to directing the questions that you're going to ask. And of course, the LADO is going to be particularly interested in safeguarding matters where that's ever more important.
Perhaps there's a related question about when you reach that decision, I think, in a staffing investigation, and that is always quite tricky. Generally, keeping children safe says you should reach an outcome once somebody's had an opportunity to answer the allegation and make representations about it. So it needs to be captured in where it's an allegation of harm that's being investigated. That needs to be captured in the terms of reference. Now, it may be that the investigation concludes that it is unsubstantiated, or potentially that it is substantiated but can be dealt with through, you know, but then could be dealt with in a different way. So it may be that, you know, that decision is reached at the investigation stage, as long as the member of staff has had an opportunity to input, and then you can speak to the LADO. But some care does need to be used, and where you think that it's likely to lead to a substantiated allegation of harm and there's going to be a disciplinary hearing, normally the investigating officer would hold back and essentially say, we consider that there's evidence there is sufficient to support that there's an allegation of harm, and therefore it then goes to the disciplinary hearing. And the disciplinary hearing, the allegation is put to the individual, including both the incident but the fact that that may constitute an allegation of harm under keeping children safe. And then they can respond to that, and then it's the outcome of the disciplinary hearing that would confirm that there was a substantiated allegation, and you would keep the LADO updated throughout that. So I'm sorry, it's not categoric, it slightly depends on where you get to. So sometimes at the end of the investigation stage, particularly of course if it's unsubstantiated, you reach a conclusion there, but otherwise it can be, you know, potential, and it would be after the disciplinary hearing usually to result in a substantiated allegation.
Thanks, Alice. I'm conscious we've got two more questions, and I'm determined to fill them, to answer both of them. So one is in terms of, is a report regarding a parental complaint, for a report regarding a parental complaint, is there a requirement to provide them with the investigation evidence? No, there isn't. You need to do what is a fair and proportionate process. Ordinarily, it's the report that will be made available in the complaints pack. It is a decision of the convener for a stage 3 panel as to whether you include all of the evidence as well. And ordinarily, the investigator will come along to that hearing. $1 million question about tips for flushing out false or exaggerated allegations at an early stage. I don't think there are. I think you have to investigate. But I think actually even turning your mind to that being a possibility and recording whether you think they're false or exaggerated, and the changes in which things have been made and the ways in which they are not consistent with records, and what you find happens can be really useful. Because what I see is people say there's a whole history of of false or exaggerated allegations. And when you actually go looking for the findings to that effect, they're often not there. So do turn your mind to it. And then the last question was, I will leave over to Alice. So I investigated a complaint about a member of staff from a parent. The complaint was upheld. They wanted to know what was happening to the member of staff. How much information can you say, Alice?
It always happens this, and in fact I was just discussing it with someone earlier today. Essentially you need to be careful, because what the parent's entitled to is to know that their complaint has been upheld and that the school is going to take appropriate action, and you could just end it there. I'm pretty comfortable that you can explain that that appropriate action will be in accordance with the school's employment procedures, but you need to be clear that the detail of that, and whether it's dealt with informally or formally, and certainly any sanction, is not a matter for the parents, and that's confidential to the member of staff. And I would usually say to the parents, you know, we upheld your complaint, we are going to address it in accordance with our procedures. You'll appreciate the detail of that is confidential. Parents don't like it, they will escalate it, they usually want to know absolutely what has happened, but that is the extent of what they're entitled to. Tabs, I think there was one other question about sharing.
Oh, apologies.
No,
Yeah.
that's okay, about grievances and whether the investigation report is shared with the employee who's raised the grievance. There is, unlike in a disciplinary context, there's no legal right for the employee who's raised the grievance to see the investigation report. However, what you want to do is make sure that the individual understands that it has been investigated and has, you know, faith in the fact that it's been investigated properly and faith in the outcome. And so it may well be appropriate to share some aspects of the investigation report. Obviously, the whole point of a grievance is, you know, to alert you to a concern, but to hopefully resolve issues. So it may not be helpful with that in mind to share all of it, and certainly not to share witness statements and things in terms of future team working. So you'll have to take a view. Obviously, if they then appeal, again, they may appeal about wanting some of the documentation. And generally, I would err on the side of being transparent and sharing things unless there's good reason not to.